I call Brett Hudson.
Thank you, Mr Speaker. It's a pleasure to rise in support of the patents, Trans-Tasman, patent attorneys and other matters amendment bill. Thank you, Dr Clark. I'll bow. Before I move on to that, because I just want to remind the House that the actual core part of this bill, the core purpose, was to replace a 60-year-old and outdated regulatory regime for the attorneys and to put in a modern licensing regime. That was the heart of the bill. So to help Dr Clark and his understanding of what empowering provisions are, empowering provisions do not mean that those provisions are the heart of the bill. Empowering provisions empower other things to take place, and they may not themselves be wholly prescriptive. That is what an empowering provision does. It empowers something else to happen. But unfortunately, Dr Clark thinks that an empowering provision is the heart of the bill. He's most certainly wrong. The two parts that the bill was intended and will deliver were, firstly, a joint registration system for patent attorneys between Australia and New Zealand, which would also include a single disciplinary regime and a disciplinary tribunal to determine complaints and to discipline attorneys as might be necessary. The second substantial part of the bill was about opposition to patents on the grounds of lack of unity of invention. And I'll cover that one first, Mr Speaker, because the lack of unity of invention was simply a drafting error from a previous amendment. What it meant was that unless you were only seeking to patent one unique piece of innovation, that someone could object to your patent and it would be application and it would be struck out. It was clearly something that had not originally been intended, and it was the purpose of this bill, and still is, to remove that odd grounds for opposition. But to the heart of it is about the registration system, which includes the disciplinary framework and tribunal. Within that, it is true that the officials had looked at a single application process and a single examination process between the two, or common to the two countries, for patent applications and examinations. What was discovered through the Select Committee process was that that was looked at some years ago, and times have moved on. Technology has moved on. There are already some applications either in place or in part being developed that would, to one degree or another, and quite frankly to almost the whole degree, supersede and nullify the SEM, as it was called, application that had originally been mooted. So it was for that reason, Mr Speaker, that it was removed from the bill. It's simply, there is no purpose for that, no reason to go to that length on our own now as things currently stand. But the heart of the bill, the heart of what is still progressing through this House, is all about a joint registration system between Australia and New Zealand for patent attorneys, one that has a common disciplinary code of conduct, and a common disciplinary tribunal. That, Mr Speaker, has always been what this bill is about. That is what it remains about, and I commend it to the House.